it is very clear that we're not infringing on the earnings of the plaintiff. So if you're saying we're earning, yes, we do earn from the master right royalties that come from that.
I'd like to refer you to your witness statement, paragraph 2. Because there seems to be a pattern that is shaping up. You say that the second to fifth defendants and myself are also director shareholders to the first defendant founding the business that I presume is the first defendant in early 2019 with the mission of developing iconic African musicians who would write soundtracks to people's lives. That is what you have stated there.
Yes.
So basically what you're saying to the court and is that there's a pattern of the first to the fifth defendants making iconic music that is not disputed. I mean, I'm sure everyone in this courtroom is a fan. But however, you are about yourselves first.
Don't lump everyone.
That's what I said, presumably, Your Honor. Presumably.
Yes,
I can be refuted. So basically what you're saying is you make iconic music and you create documentation and split sheets that makes sure that Soul Generation and Sauti Sol members get their cut first, make sure they're getting the remuneration, but when it comes to the artists and their royalties and their ability to, make a living or earn royalties for their life plus 50 years, according to the Copyright Act, that is none of your concern. You are happy to make your own money and you're happy to leave everyone else to fend for themselves.
I think
in the making of this iconic business.
I think that's a gross, absurd misrepresentation.
But you have just told the court that you are able to deal with this music using this master rights that you have said is undivided, indivisible, 100%, however you've explained it. So that gives you room and permission to deal with these musical works. But when it comes to agreeing the split sheets to enable your artist to even make a living, you don't care.
Okay, let's answer.
I think that's a gross misrepresentation of, number one, part 2 of my witness statement and what you're trying to present to the court. To the court, ours is to make sure that, number one, everybody has an equal share for how they participated within the music, the sound recording. Now, the master right is there for exploitation, right? So we have to exploit it in the sense that.
Is exploitation limited?
Am I allowed to finish?
Okay, proceed.
To the court, am I allowed to finish that?
Please proceed.
All right. On the exploitation bit, in terms of getting the music into the space so that it can be publicly played and consumed, that exploitation requires us to market and do all the other things surrounding that master right, so that as it follows, then the people who are on the other side, because publishing rights are residual rights in the sense that they come from how well the song is marketed and put out there into the public so that it can generate royalties for the other 50%, right? So in this case, what we're saying is that, no, this is not our business. No, we have not done this. There are other artists who have come from our label. Second one of those is Benso, who is thriving, and Mviri, who is thriving. As such, I can't accept what you're trying to say simply because we do not do that. We don't.
So basically what you're telling the court is that you have favorites.
Again, no.
Okay, that is fine. Let us go forward.
Let me answer your question. What I'm trying to say is the ones who we worked with to the end of our natural relationship are thriving. They thrived under us and they keep thriving after us, right? We are not in the business of playing favorites. And I'd
So
really, I would really appreciate it if you don't put words in my mouth. I think I was very, very clear in saying how we show that how we develop our artists is those two. I did not say we favored them or anything of that sort.
You said Ben Sol and who else?
Mviri, the storyteller.
Who?
Mviri,
Oh,
Nviri.
Okay.
Yes.
And you're saying under oath that Nviri, the storyteller, and Ben Sol are thriving.
Yes,
This
they
is
are.
what you're swearing to.
They
That
are
you're
thriving.
saying under oath. Now, I want that to be clear.
Yes, they Bensol
Because
and
you don't
Mviri,
want to perjure yourself and then it turns out to be
Bensol
completely
and
different.
Mviri are thriving.
And then your
Yes.
credibility to the court becomes non
I repeat.
sequitur.
Yeah, they're thriving.
Okay. The spirit of thriving. Let's see. So there is this song called Intro. Okay? Intro was the first song of the second to fifth defendant's album named Midnight Train, correct?
Yes.
It was released in, I believe, early 2020.
No.
Which year was it released?
June the 5th, 2020.
Okay, June the 5th of 2020. Okay? Right. When the negotiations between the plaintiff and yourselves were ongoing, this particular song or musical recording, musical work, was not being discussed, correct? In the initial stages.
I believe there were conversations between the plaintiff and, as per her plaintiff, the second.
But at the
defendant.
beginning of the negotiations, around 2019, the end of 2019, when she was let go by the first defendant, that song was never on the table of discussions, or rather, it was not really being discussed. Correct?
Yes, because
Yes.
we don't have the rights to discuss that song. Yeah.
We'll come back to that. And then Midnight Train was released in June 2020, as you said. Correct?
Yes.
While all these negotiations were happening. Correct?
Yes.
And the first song of that album is called Intro. Correct?
Yes.
And the plaintiff is a co-author of that song, correct?
Yes, one of the authors.
And she was credited as such on all the platforms where it was released, correct?
Yes, she was credited by us.
Yes,
Yeah.
correct. So, and then that song now came into play in the negotiations, correct?
Yes.
And you responded, as you've just said, that you did not own the rights for that song.
Yes.
And why didn't you own the rights of that song?
Because the label Universal paid for the means of production, and hence they then end up being the master rights holders, and they're the ones who are responsible for the commercialization of the album, which then includes the song.
Okay. Did you inform the plaintiff that that song was going to be part of that album before it was released?
It was the responsibility of Universal Music Group.
No.
Let me.
I'm asking a very direct and simple question. Did you, as Soul Generation, or the second to fifth defendants, as you say you're their legal counsel, did any of those entities think to say, this song is co-written by the plaintiff, let us just shoot her off an email, send her a split sheet, inform her that we're releasing it as the opening song of their album, their latest album, so that we make sure we have all our letters, our I's dotted and our T's crossed and all the legal issues are dealt with and we can move forward and release this album without any worry that infringement claims?
Again,
Did you or didn't you? Simple.
again, I think it's
Did,
not.
did you or didn't you? That is the question.
It's not a yes.
Because
or
you're
no.
kind of going around in circles, but I'm asking you a very direct
I think
question.
there has to be context because
No, the question is very
So
simple.
did you or did you not? And if you didn't, why?
okay, we did not simply because number one, at that time we already had the conversation with Crystal. She was talking. She was not talking to basically anyone. Secondly, upon release of the song, it was very clear that she had been credited. Why? We had informed Universal very clearly who all the songwriters, everybody who participated within Midnight Train, we had informed Universal. Because they were the master rights holders, it was their responsibility to then have that conversation,
So you
send
had
that email.
informed Universal
Yes.
Records
Yes, and that's why
about
she
what?
about her being a co-writer within the song itself. And that's why she was credited on all platforms as acknowledged by them. And that's why she was credited so that then Universal can, so they know who to get in touch with.
So,
Yes.
so according to you, a credit is enough. You don't need to tell them anything, you don't need to agree anything with them. Credit, enough. And you can go ahead and deal with that song with Universal Records, a third party, and the artists can just figure their way up through it in terms of commercializing her share in the intellectual property right in that song.
No, I believe we're in a court of fact. Right?
No,
So,
I'm asking
I'm
you
not-
a question about your attitude, or the first defendant's attitude to which you are here.
I don't think our attitude is in question here. I think what's in question is
No, your attitude is in question because it is informing how you are dealing with intellectual property rights.
no.
Yes.
What we did was follow up and make sure that everybody who was part of Midnight Train was credited. What then happens is the person who owns the song isn't supposed to get in touch with the people who are part of the song, right? Now, if you are credited within the song, it is not upon us to make that agreement. It is upon the label, and it is upon even the artist. That's why we credited Crystal. Then what happens in a situation is that if I was her publisher,
Can I pause you there just so that the court can record what you're saying?
Yes, carry on.
Who is the primary beneficiary of all benefits, all monies, all synchronization of that album, Midnight Train?
Universal Music,
Not Sauti Sol.
no.
So they have not received a single penny from that album. That's what you're telling the court.
Royalty check 2 years ago for our participation in songwriting.
So you've received, the second to the fifth defendants have received remuneration from that album.
Yes.
So it's not just Universal Records who have received monies from that album or any
And-
profits from that album.
And the producers who on that album,
Okay.
and the other songwriters,
Oh, so it sounds like everyone is getting paid except the plaintiff.
which means we did get
Which
in touch.
means then there is a lot of bad faith in how you're dealing with
I think
things.
again we're in a court of fact, not court of feeling.
Okay, the fact
My
is
situation-
that
what the
I
fact
put it
is
to
that-
you.
The fact is that we informed Universal.
Mm-hmm.
They did get in touch with everybody. And upon, I believe it's in one of my emails, and we said we had informed, quickly get this. when we were having a back and forth end of 2020, we advised that it would be prudent to get into a publishing deal and ask your publisher to then follow up with Universal on specifically those bits, on specifically the song intro, because we did inform them that Crystal was a co-author. And if we were acting in bad faith, I think it would have been very, I think, shooting ourselves in the foot to credit.
Is there any documentation that any correspondence you provided to the court that you did inform the plaintiff that her song intro, or a song that she co-wrote intro, was about to be the opening song of the Midnight Train album, so that you could sort out all the legalities? Because these negotiations actually proceeded till October 2020, correct?
Yes.
Yes, October 2020, which is when the first defendant agreed to sign over the master's rights to Lenga to the plaintiff, correct?
We offered.
And the master agreement was signed, correct?
Yes.
For Lenga.
Not we agreed. So that we agreed.
Yeah, agreed. No, there was an agreement.
Exactly. However,
And that is in the documents.
we offered the master rights to Lenga, and we also offered the rights to every single song that we had paid for recordings, which Crystal had recorded with us.
The master rights were signed in October 2020, correct?
Yes.
The master's agreement to Lenga, correct?
Yes.
The album, Midnight Train, as you've said, was released in June 2020, correct?
Yes.
So this means that in the back end, while negotiations were happening regarding the musical works that the plaintiff was aware of, the first to fifth defendants were at the back end proceeding to deal with the song intro without her knowledge and without her consent and to her exclusion. Isn't that correct? You said it's a court of fact, and these are the facts that have been laid
Okay.
out.
How are we dealing with them?
No. Don't answer a question with a question. The question is, you said that the master agreement to Lenga was agreed in October 2020, correct?
Yes.
The album Midnight Train was released in June 2020.
Yes.
Negotiations had started at the end of 2019 to October 2020 when the Lenga master agreement was signed, correct?
Yes.
At no time during that period, at least until June, had any conversation happened with the plaintiff and yourselves to say, oh, there's this song you co-wrote, we're using it in Midnight Train album, let's, meet up and, sign up the paperwork.
Because
That's also correct,
It was
isn't it?
not our responsibility to sign up.
Whose
paperwork.
responsibility is it
It was
then?
Universal Music Group's responsibility. I think.
If you're no. Let me just be
me-
clear.
Yeah.
Because there's a little bit of a dance that you're doing, and I want the court to be very clear that the facts as are stated in the documentation that has been provided, that you have not provided any documentation to say you gave the plaintiff information that that song was going to be used in the Midnight Train album. The Midnight Train album was being marketed and released as a production of Sauti Sol, not as a production of Universal Music Group, correct?
No.
No, correct or
It was,
no?
It was.
What is the name on the album cover of that album?
Midnight Train?
Is it Midnight Train? And who are the credited artists for that album cover, on that album cover?
Everyone credited with.
No. What is the name that is written? There's above Midnight Train, there's the artist name above. Who is the artist written up there?
And Sauti Sol.
Sauti Sol. There's nowhere on the album cover that is written Universal Record Group, correct?
It's in the corner of the album.
So the primary beneficiaries to the money that is being made out of that album is Sauti Sol, regardless of what assignments or agreements they've done in the back
Is
end, correct?
Universal Music Group, and I believe we produced the agreement for that. We produced the agreement for that.
Again, when was that agreement brought to light? When was that agreement brought to light? Was it brought before this suit was instituted?
I don't think that when it was brought to light was relevant. What we did
It wasn't relevant to this suit?
I'm saying when it was brought to light, it wasn't relevant. We had made it very clear.
It is relevant. Because you
Again,
are telling the court that the person that the plaintiff should have been dealing with is Universal Music Group. So how does the plaintiff know who they're supposed to deal with if that information is not made
because
available to them?
We had made it clear.
To whom?
To you, once we had started when we started having the conversations around this, and there were demand letters back and forth, and we within one of our responses to your demands, we did make it clear in the sense that on the Universal side, on the Intro side, the conversation should be had with Universal.
So what you're saying essentially is that it is okay for the first defendants, or the third, fifth defendants, because this is involving an album that was released by the second to the fifth defendants. It is okay for these parties to go and get a songwriter, an artist, anyone, come up with song lyrics, arrangements, etc., whatever components constitute a song, record that song, produce it, and then go and deal with it with a third party, and then tell that rights holder that, hey, it's not our problem. Go find Universal Music Group in where? South Africa, isn't it? Isn't that where they are based, Universal Music Group, according to the agreement that is filed? Isn't that where Universal Music Group is based?
Yes.
In South Africa.
Yeah.
So an artist of little to no means, any artist, is supposed to climb that uphill battle, while the first, the fifth defendants sit pretty knowing they have made their, whether it's the initial cut or future royalties. And that doesn't seem unjust to you, or unfair, or bad business practice, apart from it being against the copyright laws?
I think
That seems okay to you?
I think we need to put some things in context, right?
No, I've just asked a question
Again,
because you as a member of the first, the fifth defendants, and you as a lawyer that you have said you are, knowing what copyright law is, because you've given lectures on copyright law, as you've told the court, and you understand the business, as you've told the court, and you understand that the copyright law in Kenya is thin, right? So to you, in your expertise and in your knowledge and your professional knowledge of what is just and fair, does that sound right to you? Yes or no?
I think you've posed a 2-minute question. It can't be a yes or no.
You have talked too much, Mr. Asige, until now it became, like comments. Because it's too much.
Okay, I can rephrase. No, but what I'm trying to do, my lady.
To the extent that you lose him.
No, I think he understands me. But I will repeat it and I'll break it down.
Can you just narrow it down and ask the question?
Okay.
Ask the question.
Yes, my lady. I'm just making it shorter in my head. So what you've said, Mr. Mambia, is that the first, the fifth defendants are able to collaborate with other artists, create music with them, and then deal with that music with third parties. And then when that collaborator wants to assert the intellectual property right, it is just unfair for you to say, well, we've dealt with another party owns it in South Africa, Universal Music Group. So too bad, you deal with it yourself. Does that sound correct to you? Or just? Or in line with the copyright laws or the intellectual property laws of Kenya?
That's a question now answered.
Okay. I think context is important. Number one is that when we're having these discussions are not, again, they're not the most friendly of discussion, right? And secondly, we're dealing with the issues as raised. That's number one. On why it wasn't brought up between June and October. And when it was brought up, we thought it prudent to direct the plaintiff to the people who would handle the situation most expediently, because, and this is through proof of the credits that were given to the plaintiff, is that we had informed them that she is a co-writer, right? So within that, it was our expectation that the label would have dealt with it. And when it was raised, it was our expectation that upon directing the plaintiff to the right people to talk to get it dealt with expediently, they would be able to reach out to them and make sure that it is sorted, because we had informed Universal that she was a co-writer within that one song in the 15-track album, and to make sure that she is credited. We did not act in bad faith, simply because we made sure that the plaintiff is credited for what she was doing, for what she did for that song, which is very important, right? So no, to answer your question.
Does a credit mean...
We do not act in bad faith. And where you've asked, are we acting against copyright law? No, we're not. Especially when it concerns this song, right? Simply because, again, her credit was given, and yes, two parties did not communicate, but that didn't. If we're acting in bad faith, in that situation, I think people acting in bad faith don't intentionally shoot themselves in the foot.
Okay, have you provided any proof of this communication that you had with Universal Music?
The proof is in the credits that were given.
No, the conversation, the
proof
correspondence.
Is in the credits.
No, a credit does not equate to a correspondence. Do you have you put...
Like you said, Universal Music is in South Africa. How would they know Crystal was part of the songwriting group?
Answer
Exactly.
the question. It's a specific question. Answer that question. Don't evade. Because that's what you're doing. Do you have that correspondence here in court?
No.
So there is nothing, we cannot rely on what you're saying about that correspondence. Is that correct?
I think we can rely on your plaint, which says that she was duly credited.
Does a credit equate to monetization or enforcement of that credit?
The credit allows for the plaintiff to instruct her publisher to then enforce that credit.
So, in conclusion, there have been several instances where the fifth defendants, as we have through this cross-examination, both the third parties being Universal Music Group South Africa, the Netflix producers for the TV series Country Queen, and the sixth defendant. So you have shown that there is a pattern of dealing with musical works involving other artists to their exclusion. Isn't that correct? Regardless of the reasoning and what you feel about what you're doing, isn't that a pattern that has been established? Yes or no?
No.
It isn't a pattern. It's just coincidence.
So to the exclusion. I believe on the Country Queen agreement, there is the songwriters who are all credited, right? And on that side, we have not earned anything until this matter is resolved.
And my final question, are you aware whether the plaintiff has received a single shilling for any of these artistic works that have been forthcoming today? Has she received anything?
I think it's her responsibility to get the publishers and the publishers to chase those funds.
Her responsibility?
Yes.
Okay. My lady, I have no more questions.
Can I answer that question? There's one more bit I need to answer.
I've concluded, my lady.
is it? I have a meeting to attend. So I
10
have to
minutes.
leave before.
10 to 2.
I have to go. So this matter will be continued in the next available date, and the dates available are for next year. So there is still cross-examination, re-examination, and one more witness.
Yes, my lady.
Which dates are available? And the times we have available are for 2 p.m. in the course of next year. In March. Yes? The 3 days, which will be 2 p.m. So 23rd March, and 20th,
23rd, 24th.
and another week, none. So 23rd and 24th of March, 2026 at 2 p.m.
2026 at what time, my lady?
2 p.m. All the other dates are taken in March, and the time, the morning time is already taken.
Very well, my lady.
You may sit down, Mr. Mabi.
Oh, thank you.
Okay, thank you for your patience. So the time now being 1:50 p.m. and noting that I have a bar bench meeting to attend together with other judges and lawyers who practice in the commercial and tax division. The case is adjourned. It will be heard on 23rd and 24th March 2026 at 2 p.m. in open court.
Most obliged, my
Well,
lady.
most obliged, my lady.
So see you next year. God willing.
Wish you a Merry Christmas for those of us who have seen.
Okay, thank you.
Thank you.
Have a good